for all the colleagues that have been able to join us today. And I'm sure as we progress, more colleagues are going to be joining us online. And huge appreciation, Jan, to yourself, Peggy, to you, as well as Emanuela, for being part of today's IASC briefing on the obligations of occupying powers during armed conflict. So colleagues, under the rules of international humanitarian law, particularly the Geneva Conventions, there are clear protections in place for people living under occupation during armed conflicts, These laws are designed to shield civilians from horrors of war and ensure they are treated with dignity and respect. These rights are fundamental and non-negotiable. Yet, despite these strong legal protections and comprehensive legal frameworks, alongside the principles enshrined in the UN Charter, we continue to witness severe violations around the world, affecting millions of innocent lives. And colleagues, that is why we are here today. We're here to learn more about these important legal frameworks. We're here to discuss the importance of upholding these laws. We are here to underscore our shared global responsibility to enforce them. Because without them, as we all know, we will continue to witness unimaginable suffering and loss of life. So again, I'm very happy, of course, and extremely honored to have Jan Egeland, who, as all of you know, he's the Secretary General of the Norwegian Refugee Council. Welcome, Jan. Thank you again for joining today's panel. Also joining us today is Peggy Hicks, and she is the Director for Thematic Engagement, Special Procedures and Right to Development with the UN Office for Human Rights, OHCHR. And finally, Dr. Emanuela Chiara Gillard. Lovely to see you again, Emanuela. After so many years, she is a Senior Research Fellow with the Oxford Institute for Ethics, Law and Armed Conflict and Chatham House's International Law Program. As with usual practice, colleagues, we will start off from hearing from our speakers, brief interventions, and then we will open the floor for comments and questions from the participants online. So, Jan, I'd like to first turn to you, and I know you don't need an introduction. However, if you would allow me, I'll say a few words for colleagues that are online, who I know join us from different parts of the world. You're not only a veteran with more than 3 decades of dedicated service in the field of human rights, humanitarian aid, and conflict resolution, but you have also held some of the most crucial roles in international diplomacy and advocacy. You have a long and distinguished career, including serving as Under Secretary General for Humanitarian Affairs and Emergency Relief Coordinator, and also as State Secretary of the Norwegian Ministry of Foreign Affairs. So Jan, you have been a consistent champion and advocate for the protection of civilians and a strong voice for people affected by humanitarian crises. So I'd like to turn to you first to set the tone. Could you share your perspective on the implications of violations of IHL in situations of occupation, particularly in terms of the ability to protect and assist communities? And if you can also elaborate on how humanitarian organizations can effectively navigate the complex environments under occupation, then that would be extremely helpful. Over to you, please, Jan.
Thank you very much, Mervat, and thanks for organizing this session. It's good that so many are interested in this area. As humanitarians, we have operated on occupied territory for decades. I have myself been dealing with the Palestinian-Israeli conflict now since before the Oslo Agreement, and my organization is very active there. I see a colleague, Itai Epstein, expert on humanitarian law, and several other experts. To start with, we need to know the laws as humanitarians to be able to help people in the hour of greatest need as civilian populations in occupied territories. It's a job to be with them and provide for them. And it's not a free for all in terms of parties and violent men there. There are rules. The rules came after on the rules of the Second World War, and the Fourth Geneva Convention is a detailed document saying that what happened during the Second World War was terrible for the civilian population. We had the Holocaust. We had all of those horrific atrocities. So the rules are detailed in the Fourth Geneva Convention. And in the 70s, 1977, there was additional protocols for international armed conflict and for intra-state war, civil wars. Second protocol, especially the first additional protocol, is detailed on the occupying powers obligations. We have a right to provide assistance, and the people have a right to receive assistance, and the obligations of the occupying power is severe. Protect the civilian population, protect others who operate there, including the aid workers, the medical professions, hospitals, our facilities, etc., supposed to be protected and our work facilitated. When is there an occupation? That is usually given by international bodies, the Security Council or intergovernmental institutions, etc. It's important usually that we don't wade into, as humanitarians, no, I find this occupation and I think the laws are applicable like this or that. Well, it's supposed to be already decided by the UN or another authoritative body whether there is an occupation, and thereby the convention and the protocol is applicable. Now, so by occupying a territory, you have severe obligations and so on, and among them again, facilitate our work. We're supposed to have the access to the territory. We're supposed to have the opportunity to have safe distributions. There is the occupying power is supposed to make sure there is public order and safety, that they have no right to interfere in our work and do aid diversion. Of course, then again, that's why it's important to know the law and stay principled. Of course, it's then debatable, is the occupying power would say, no, there is a military necessity for us to do this and that, to be here and there, to have to act like this and that, to have roadblocks like this and that, and so on. And often then a difficult discussion starts. Is there a military necessity to this or that or not? We are independent, neutral, and impartial. The humanitarian operational principles is a rule book in itself. Let's stay neutral. We don't have opinions on the political outcome of this, of that, or whether or not the military actor should do this or that, except when they infringe of the rules and the regulations, and, for example, have excessive or indiscriminate use of force. One example. NRC that has a lot of expertise in this, we invested a lot in that, came out very early, and we were criticized at the time by the occupying Israeli power. We said that the order to relocate, evacuate from northern Gaza could be an atrocity crime because it was a forcible transfer of people. Clearly outlawed under international law, because it was not orderly, it was not organized, it was not safe, it was not to places with facilities, and there was no right of return to your place of origin. We did it the same again now with Rafah. We used the law as such on this. Of course, advocacy in such a situation can be a little bit dangerous and a little bit costly. And in NRC, we have decided to be very outspoken and call a spade in such situations. Of course, the occupier would not like this advocacy, that we find their warfare indiscriminate and not proportional and not having distinction between military and civilian targets, etc. The other side will also not like it when we criticize them for blending into the civilian population, which is illegal, or by themselves attacking civilians and being indiscriminate. Now, moving on, I think among the difficult issues here is the issue of accusations of bias or breaches of neutrality. What do we do with the pier in Gaza, set up by the US military, which is supporting the Israeli military with arms and whatnot, and also a pier, which is then guarded by the Israeli army and seen as part of the military campaign, not just the occupation, but the campaign. At the same time as the occupying power is supposed to bring aid to the civilian population and keep order and public safety. What is correct? What is incorrect use of force? What do we say when we see those things? When we see errors? And how do we guard that we're not seen as part of the occupation by being cooperating with the occupying military? I think it's an additional issue here that precisely that our main donors may take sides in conflicts where we are neutral and impartial and independent. What about it when our donors give both arms and humanitarian aid? And at times in the same supplemental or the same package. I've criticized publicly in my own country that in Ukraine, there is a Nansen package. Some of you may know that the first refugee commissioner, High Commissioner for Refugees, was Fridtjof Nansen, Norwegian explorer. We're very proud of him. This is 1920s, League of Nations. The Nansen program has big and generous civilian components, including humanitarian aid, and a military component, grenades and armored vehicles. And with the same program, and it doesn't look good. And it's launched on the same day where the humanitarians and military speak on the various parts of the same program. It's important to distinguish as much as possible in warfare, but and perhaps especially when there is occupation. Now, we need to again then insist that there is humanitarian diplomacy by those who can influence the parties to the conflict, including the occupier. We have succeeded only to a limited degree, both in the two most famous cases, which is occupied Palestine and now Gaza, and the other one is the Russian occupied areas of Ukraine, where we were thrown out, my organization and many others, from the Donbas in 2015 after the half of Luhansk and Donetsk were taken in 2014. We were thrown out in 2015, and it was very clear that the Russian influence made that happen. Now these are annexed areas. It's very clear it is occupation, and the international community has very little humanitarian access there. And we need to be able to serve people in need equally on both sides, and it pains us that we're really just on one side in Ukraine. And it's a problem then for us, really, that we are not able to portray, to be accepted for operation on the other side. In part, it seems, because we're seen as so close to the other side and to those donors who give economic, civilian, humanitarian, and military aid in one mix, and they become partisan. And then maybe I'm taking time here, and then by saying what we need, I think, is more active, and here would like to see the UN leading much of this diplomacy with all of the member states on access, where it is not just the occupying power, but it is the previous government still existing, the armed opposition groups and other actors all have a say in the situation there, and all need to help us protect civilians and give access. We need much more robust humanitarian diplomacy with all actors based on humanitarian principle, international humanitarian law, and we need risk sharing. It's difficult, it's dangerous, and it's costly, and it is, and we will be making mistakes in this area. There need also to be risk sharing with donors and member states so that we can stay and deliver for people under occupation. I'll leave it there.
Brilliant. Many thanks again, Jan. Again, your message is very clear around the importance of all of us as humanitarians, of course, in this field, to be comfortable and know the law, to be able to operate more effectively in contexts where there are, of course, occupying powers, and to be familiar with the obligations of occupying powers. And I think that's one of the reasons why, of course, we are holding this important IASC briefing. I think you also spoke about the importance of realizing and acknowledging the role of occupying powers when it comes to facilitating humanitarian assistance, facilitating the access, the safety of course, the population, but also humanitarian workers and different infrastructure to be able to deliver assistance and for populations to access assistance and protection. You also underscored the importance of humanitarian diplomacy and striking a balance between public advocacy and humanitarian diplomacy, and your call for the UN to do more when it comes to humanitarian diplomacy for access and protection, but also the importance of member states and donors when it comes to, of course, risk sharing and using their leverage and influence to be able to influence our ability as humanitarians to work and to ensure the protection of civilians. I'm sure there's going to be quite a few comments and questions, Jan, for you. Perhaps taking this opportunity to turn to Emanuela. Again, Emanuela Chiara Gillard is a senior research fellow at the Oxford Institute for Ethics, Law and Armed Conflict. She has extensive experience in humanitarian law and civilian protection, having served as chief of the protection of civilians section with OCHA. Additionally, she was legal advisor at the ICRC, amongst many other important roles. So with that, Emanuela, and building on Jan's interventions, it would be great if you can also shed light on further light on the obligations of occupying powers in terms of humanitarian relief operations, so the legal aspect of it. This will help us understand the legal framework concerning the duties during an occupation, particularly focusing on humanitarian actions. And perhaps before also going into this particular question or addressing this particular question, if you can also clarify the difference between occupation and annexation. How are these two situations related from a legal standpoint? Over to you, please, Emmanuel.
Great. Thank you very much, Mervat. It's really an honor to join you today. And I will take your questions in reverse order, because I think it's important for us to have a shared understanding of what we're actually talking about. So first and foremost, what is occupation? And we do have a legal definition of this in the Hague Regulations of 1907, so an old definition, which says that territory is considered occupied when it is actually placed under the authority of a hostile, so enemy army. It's important to bear in mind that occupation extends only to that part of territory where such authority has been established and can be exercised. So this means it could only be part of the state's territory that is actually occupied. And importantly, that the mere presence of enemy armed forces in the territory of a state doesn't mean we're in a situation of occupation. So as Jan has already pointed out, we have this legal definition, but whether or not territory is actually occupied is a determination that needs to be made on the basis of the facts on the ground, not what people say, but what the facts are on the ground. Another important point that we need to be aware of is that occupation is a concept that only exists in relation to international armed conflicts, so conflicts between two states. There is no notion of occupation in relation to non-international armed conflicts, so conflicts between one state and an organized armed group that we frequently see in current conflicts. So even if an organized armed group controls territory and has and is exercising effective control over it, which would mean it's an occupation in an international armed conflict, if it's an organized armed group, it is not capital O occupation, and the law of occupation doesn't apply. However, organized armed groups do have significant obligations, in particular towards the civilian population of these areas under international humanitarian law. And increasingly, we see the argument made that in such situations where they exercise effective control, armed groups also have duties under human rights law. So now that we've understood what occupation is, what are the legal consequences? Once territory is occupied, the occupying power must comply with the law of occupation, which, as we heard already, is found principally in the Fourth Geneva Convention of 1949. And these are additional obligations to those that would already be applying to the occupying power because it's a party to an international armed conflict. The law of occupation is quite complicated, and it's a series of legal relationship between the occupying power, the ousted occupied state, and also the inhabitants of the occupied territory. I'm not going to enter into the details here, but just to flag two overarching aspects of the relationship between the occupying power and the population, which is relevant to our conversation today. First, and very importantly, an occupying power must take all the measures in its power to restore and ensure, as far as possible, public order and safety. And this is understood very broadly, l'ordre et la vie publique, so ordinary life in the occupied territory. And then secondly, an occupying power has positive obligations in terms of the security and welfare of the civilian population. This includes the obligation, to the fullest extent of the measures available to it, to provide adequate food, medical supplies, essential medical services, and so on and so forth. And again, I emphasize, these are obligations in addition to those that a party would already have under the rules of IHL, for example, governing the conduct of hostilities. Again, in terms of the law, it's generally accepted that human rights law continues to apply in situations of armed conflict, including occupation, but the precise role that human rights law plays and its precise interplay with IHL needs to be determined issue by issue. So that's occupation. What about annexation? Now, annexation is the purported acquisition by a state of the territory of another state by the use of force. It is not a permissible way of acquiring territory, as it violates the prohibition of the use of force, a preemptory rule of international law. Acts of annexation do not transfer the title to the territory in question. It remains the territory of the invaded state. Instead, provided the invading forces have effective control, as we mentioned before, the territory is to be considered occupied, and the law of occupation continues to apply. There are also consequences for third states. States must not recognize as lawful situations created by violations of preemptory rules of international law, such as the prohibition of the use of force. So third states must not expressly or implicitly recognize purported annexation of territories. Now, this is very clear from a legal perspective. However, problems may arise in practice, including when seeking to conduct relief operations, because in doing so, NGOs, the UN, must refrain from conduct that could implicitly recognize the title to territory by the annexing power. So simple as a matter of law, complicated once we actually look at what it means in practice. And I'm now going to just come back to your first question. What are the occupying powers' obligations in relation to relief operations? And this is one of the areas where IHL lays down specific obligations for occupying powers. Now, the starting point in all situations is that primary responsibility for meeting the needs of civilians lies with the party in whose control they find themselves. In situations of occupation, this is the occupying power. And this means, as spelled out in the Fourth Geneva Convention, to the fullest extent of the means available to it, an occupying power must ensure the food and medical supplies of the civilian population, as well as clothing, bedding, means of shelter. And I always say, let's not overlook this first step. It's important to always responsibilize the occupying powers. Primary responsibility lies with them. Now, if despite an occupying power's obligations in this regard, whole or part of the civilian population is inadequately provided with supplies essential to its survival, the occupying power may not withhold consent to offers to conduct relief operations that are humanitarian and impartial in character. And it must allow and facilitate their rapid and unimpeded passage. This is very clear. However, there's always a quid pro quo. An occupying power is entitled to prescribe technical arrangements for the entry into the territory and the movement within the occupied territory of relief operations. This can include the search of consignments to check they don't contain weapons or military equipment, the requirement that relief convoys use prescribed routes at specific times to ensure they don't hamper and are not endangered by military operations. Always bearing in mind, however, that restrictions may be imposed on the activities or movement of relief personnel only in case of imperative military necessity. For example, if there is a military operation in a particular location, and even then only temporarily. And an occupying power can also decide which actors can conduct relief operations, provided that the needs of the civilian population are met in an impartial manner. And my final point to bear in mind is it's not just the occupying powers that have obligations vis-à-vis humanitarian relief operations. All states must allow and facilitate their rapid and unimpeded passage. And this includes, for example, the states neighboring the occupied territory.
Super clear and extremely helpful, Emanuela. I very much appreciate also you highlighting the obligations, not just to occupying powers, but also all states, including neighboring countries, but also other member states that have responsibilities in terms of influence and how they're engaging with the occupying power. I think the message is also very clear around the importance of the occupying power when it comes to restoring and ensuring public order and safety, the role and the obligations of occupying powers when it comes to security and providing assistance and protection. And also the fact that in terms of the labeling of occupation, for a lack of a better word in terms of labeling, is that it's a legal recognition and it's based on facts, not opinions and impressions or perceptions. So with that, again, many thanks, Emanuela, and I know we'll circle back to you again with questions and comments from colleagues online. But turning perhaps to Peggy, again, Peggy, thank you so much for joining us again today. Peggy Hicks is the Director of the Thematic Engagement Special Procedures and Right to Development Division at the UN's Human Rights Office. And she has previously held roles as Global Advocacy Director at Human Rights Watch and director positions with UN missions in Kosovo and Bosnia-Herzegovina. So Peggy, with that, I think I'm sure there are lots of questions and thoughts from participants, as I'm sure it is the case for all of us in terms of the compliance and the accountability aspect. Because of course we heard from Jan in terms of the implications on humanitarian operations. We've heard from Emanuela on the legal framework and clarifying, of course, the obligations of occupying powers and member states. Now he would like to learn more about how can obligations that apply under IHL in situations of occupation, how are they to be implemented in practice, and what are the operational implications on the involved stakeholders? Over to you, please, Peggy.
Great, thank you so much, Mervat. Very happy to be part of this discussion, and I think it'll be a little bit of a refresh on some of the points that Jan and Emanuela have made, which have already brought in some of these important topics as well. Just at the outset, I want to emphasize the extent to which we in the UN Human Rights Office see protection as the core of humanitarian action. It aims for full respect of rights of individuals in accordance with not only IHL, but international human rights law and international refugee law, as has been mentioned. And what we're seeing today, of course, more than 50 active conflicts across the globe. And we're seeing, unfortunately, a critical erosion of these normative frameworks with, real flagrant disrespect for international law on a scale that is incredibly worrisome. We're concerned that the pain of people, the other, is not acknowledged, and that dehumanization has become increasingly common. And of course, we see and feel with you all within this group of humanitarians the impact of this on humanitarian responses from Gaza to Ukraine. Protection actors are increasingly being marginalized and targeted, with humanitarian principles as well at risk. So in that context, we wanted to highlight sort of 5 messages. The first is, relates to your specific question about the challenge in implementation of international humanitarian law. First of all, just to emphasize, our office has been vocal on the responsibility of occupying powers and will continue to do that. One of the problems, though, is really around the question itself, where we jump directly to talking about the modalities for implementation, but the reality is the issue that we confront and we observe through our monitoring is a threshold issue of lack of willingness by occupying powers to implement their obligations. So it's hard to get to the modalities when there isn't that threshold willingness barrier exists. The basic principle, as has been said, of the law of occupation is that it is the occupying power that temporarily takes over those responsibilities, and they must, of course, then respect human rights obligations. So the second point is really then to look at, as Emmanuel has stated as well, the relationship between international humanitarian law and international human rights law. And they are, as has been said, applicable in a concurrent and complementary manner in situations of occupation. So IHRL, human rights law, is directly applicable in situations of non-hostilities, for example, in law enforcement operations in occupied territories. And while these two bodies of law supplement each other in situations of occupation, the fullest practical protection can be provided when both sets of obligations are applied and implemented in their entirety. So humanitarian law recognizes that people living under foreign occupation factually can sometimes not benefit from the same protections that nationals of the occupying power enjoy in their own country, and therefore they get specific protections. An example of this is in Ukraine, where we've observed, for example, that the Russian occupying authorities have compelled protected persons to serve in Russian armed forces and have imposed Russian citizenship on protected persons. These actions may not violate human rights law directly, but they clearly violate humanitarian law provisions. In some cases, occupying powers, as you know, dispute the qualification of occupation. Dialogue based on the law of occupation, then it becomes almost impossible, as I've noted. And then in those situations, of course, the fact that human rights law has extraterritorial application continues to offer protections for the population in these occupied territories and may then, of course, be another basis for engagement. As has been noted, the positive obligations of an occupying power are as, or if not more important than the prohibitions contained under humanitarian law. And those obligations, as noted, include health, food, education. But I'd emphasize that while international humanitarian law does provide protection for those rights, it sometimes isn't as detailed in what it says those rights entail. And that's where applying international human rights law can be helpful, because it includes interpretations of those rights that have been developed by the broad range of human rights mechanisms, in particular on economic, social, and cultural rights. And that provides a greater understanding of the extent and scope of the occupying power's duties under those positive obligations. I'd also note that while criminal accountability mechanisms such as the ICC play an essential role for individual accountability, and of course we're having this briefing at a moment where that it has been very much in the news with the prosecutor's decisions, and our call, of course, is to respect that legal process. And to allow the pretrial chamber to go forward to undertake its work free from pressure and action. But at the same time as mechanisms like the ICC work, we also want to recognize that the international human rights framework brings in a multiplicity of other mechanisms that can also help focus on state compliance with human rights obligations and state responsibility. And those mechanisms include the treaty bodies. I already referred to economic, social, and cultural rights, to the committee that interprets the Covenant on Economic, Social, and Cultural Rights, for example, and the special procedures, which are part of my area of responsibility in this office, of the Human Rights Council, a wide range of thematic and country mandates, and of course the Universal Periodic Review. They've all looked at compliance under both IHRL and international humanitarian law in situations of occupation and have issued relevant recommendations in a variety of settings. So I'd urge you to look at those as places to provide guidance and support for your engagement. The third issue is one that you've heard from my fellow commentators, but I really wanted to emphasize the importance of the occupying power's obligation to ensure public order and safety. As noted, this comes from the original French text of the Hague Regulations of 1907, which say very much it includes an obligation to ensure continuity as much as possible of ordinary public life. And that means that an occupying power isn't able to simply implement which parts of occupation law that it wants. It can't pick and choose within this body of law, applying certain provisions and not respecting others. It has to, in particular, meet this duty to ensure public order. And that means that it needs to take certain actions. The ICJ, for example, in its judgment in the case of armed activities in the territory of the Congo, stated that this obligation comprises a duty to secure respect for the applicable rules of human rights and humanitarian law, and to protect inhabitants of occupied territories from acts of violence, and not to tolerate such violence by any third party. And we can come back to it, but of course, we've done reporting recently on the situation in the West Bank, where the level of violence that's happening and its relationship to the role of the ISF and settlers' engagement in those activities is certainly a matter of concern for our office. The fourth overarching message we wanted to convey relates to the human rights impact of lack of compliance with the law of occupation. Our monitoring situation of occupation has allowed us to conclude that most violations of human rights law flow from the lack of respect for the law of occupation, including in situations of de facto or de jure annexation or transfer by the occupying power of its population into the occupied territory, as observed in the cases of the occupied Palestinian territories in Ukraine. The humanitarian law requirement that the occupying power minimize changes to the status quo ante are designed to protect people's rights during occupation and to preserve legal and administrative systems, creating conditions for the territory's reintegration. And therefore, it means that the lack of respect for the law of occupation has a really negative effect on future peace negotiations and agreements, as well as the end of the occupation and return of control of the occupied territory to the territorial state. And as has been mentioned, I won't go into the details now for lack of time, but if you look at the situations in Crimea and in the territory of the Ukraine, the fact that the Russian Federation has imposed their own systems of law, administration, and justice systems, measures targeting education and cultural identity, imposing curricula and language, are exactly the types of actions that we're concerned about and which go against their responsibilities as occupying powers. And then finally, a point that's been raised, I think, by both of the prior speakers and that we want to emphasize as well, is the responsibilities and involvement of third states. Recent cases, as I've said, have demonstrated a lack of willingness by occupying powers to respect their responsibilities under humanitarian law. And that, of course, means that practical implementation, which is the question Mervat asked me, requires the active involvement of third states. And under the Article 1 of the Common to the Four Geneva Conventions, all states must not only respect, but ensure respect by others. I'm sure that's familiar to all of you. And that means that third states must take active steps to bring about bring violations of the convention to an end, and an errand party to the conflict back to an attitude of respect for the conventions, and they should use their influence on that party to do so. And so, for example, that raises, as Jan has pointed out, concerns when a state participates in the financing, equipping, arming, and training of armed forces of a party to a conflict, or even plans or carries out or debriefs on operations jointly with such forces. And when they have that ability, that allows them to exercise influence to ensure respect for humanitarian law and that obligation under the rules of relating to third states and occupying powers. So I'll close there and looking forward to the remaining conversation. Thank you.
Thanks a million, Peggy, and hugely appreciate, again, your explanation of the interplay between IHL and international human rights law, and becomes, of course, very critical in ensuring that all measures of protection are met comprehensively, addressing both the legal as well as, of course, the human aspect of conflict. And thanks for bringing, of course, the human aspect to this conversation and the implications of these violations, if I may say so, in dehumanizing populations that are under occupation. So I'm seeing a few questions coming in, and perhaps I'll start off just turning back again, Emanuela, to yourself. There's a question from Norway. Could you elaborate a bit more on the rights of the people under occupation? Is it so that they have the right not only to basic services, but they have the right to also basic services and protection, but they also have a right to, for lack of a better word here, rebellion. So this is one question that would be great to hear your views on. And I'll circle back again, Jan, to yourself as well as Peggy with the questions that have come in. So over to you, please, Emanuela.
Thank you so much. Obviously, an important question. In fact, it is not something that's addressed by international humanitarian law, which instead focuses on the obligations of parties to the armed conflict and limits what they can and cannot do. So to the extent, we're talking about the law of armed conflict. So the moment force is used, everyone needs to comply with international humanitarian law. This is important to bear in mind, all sides. So the moment the population carries out activities that amount to taking direct part in hostilities, they lose the protection that they have as civilians. So we're in the law of armed conflict. I think what's important to bear in mind are the protection, the restrictions that IHL imposes, that Jan was beginning to outline in terms of what a party can and cannot do. So that relates to the limits of the objects against which attacks can be directed, and also very significantly the obligations to take constant care in all military operations to spare the civilian population, and then the effects of activities more broadly on services that are necessary to the civilian population. So as you can see, I'm answering a rather different question, because that's how IHL works. It works in terms of limiting what parties to an armed conflict can do and limiting the effects of the conduct of hostilities on the civilian population.
Thank you, Emanuela, and perhaps maybe turning here to Peggy, and specifically there's a question on the aspects of compliance. Is there a way to ensure compliance besides sanctions? And again, Emanuela and Jan, you're welcome, of course, to come in to answer this particular question. Another part of that question is, what are the implications of non-compliance for both the occupying power?
Great, thank you, Mervat. I think the compliance issue is obviously a tough one. I think both of my colleagues will probably have more to say on it. You know, for us, the last points that I made, I think, go directly to that. You know, there is an obligation to use the influence that you have and engage. And as Jan mentioned as well, this his call for robust action by states and others to engage in advocacy around humanitarian access and other issues. All of those are responsibilities that are essential to compliance. I noted, of course, though, the challenge of enforcing obligations of an occupying power that doesn't believe it's an occupying power. And obviously that, you know, overcoming that hurdle and figuring out how to engage in a conversation about these legal obligations, which Emanuela has detailed at length, are applicable in these situations, is you know, as a difficulty for all of us. And that's why, of course, you know, we look to human rights law as well as helping, because of the fact that the dispute over its applicability should not exist in the same way. But in terms of how it ultimately can be leveraged to you know, get states to change their behavior, obviously the mechanisms on the human rights side are authoritative but not necessarily influential at times. And we know that states in general do you know, ask for, agree to abide by certain human rights. If you look at their universal periodic reviews, they all do that, but that doesn't mean they are necessarily going to do what they say. And certainly in areas of conflict, it's even more of an issue than in others. But I expect my fellow panelists may have more to say on this point.
Thank you, Peggy. Just maybe turning Jan to yourself, if there's any additional comments from your end.
Compliance is the thing, of course. In a circumstance where the parties to the conflict, which is the occupier, the previous or recognized government, and the insurgents or armed groups, may have very opposing views of what is the facts, what has happened, why things happened, etc. Which means that for us, the facts has to be correct. We cannot use hearsay or use biased information or use information coming from parties. We have to have the facts, and as humanitarian, we're often on the ground. So we have facts that we can bring forward. And then you need to know the law as well. You know, again, I mentioned this, it's just been very difficult now in Gaza. Is it then humanitarian evacuation what's happening, or is it a forcible transfer of people? One is illegal, the other one is not. To fly pretty safe Norwegians back from Israel on the 8th of October voluntarily is very much humanitarian evacuation. to say you need to leave. A drone comes to a school and says you have 3 hours to leave Khan Yunis and go to Rafah, drop everything and leave. And there is and we're not guaranteed there is anything waiting for you or your right to return. It's illegal. I mean, it's so we need to bring the facts forward. It's I think on one aspect which I forgot is the whole issue of land rights, colonization, and I think you mentioned annexation, Emanuela. It's illegal to move away the original population and move in your own population. It's illegal in the West Bank. It's illegal in the Donbass. It's illegal anywhere, really. And where we who work a lot on information and counseling and legal assistance and housing, land and property rights, because we're very much involved in that on the West Bank. But yet again, the facts are important and the law is important. These are Bedouins. They've been here for a generation and they were moved here because of the creation of the State of Israel in 1948. They are now supposed to leave to have a shooting range for the occupying force. Not legal in our view at all, and we need to prove that before and we need to speak up. Also the point again, to speak or not to speak, that is the issue very often. It's not in violation of neutrality to be partisan for the civilian population and their rights. What is wrong as humanitarian is to say we're pro-Palestinian, or we're pro-Israeli, we're pro-Arab, we're pro-Jew, we're pro the civilian population only.
Many thanks, Jan. Perhaps with that turning, we have quite a few questions that have come in, and I know I'm conscious that we have 25 minutes to go, and I want to go through as many of the questions that have come in as possible. So maybe turning back again to you, Emanuela, it would be good to learn a bit more about who bears the responsibility for qualifying occupation and annexation. Over to you, please, Emanuela.
Great, thank you. And that's a really excellent question. And I would actually broaden it out in terms of who who qualifies the situations even as armed conflict and determines whether they're international armed conflict or non-international armed conflict. The question says who has the responsibility, the mandate for doing this, and the answer is no one. No one is tasked with this. In practice, a multitude of different actors do this for different reasons. So let's be clear, the Security Council has an obligation to look at threats to international or threats or breaches to international peace and security. This is a different notion to determining whether or not there is an armed conflict or occupation. However, in practice, you can see whether the Security Council considers the situation as armed conflict, because it'll call upon parties to comply with the law. It might also call, in its statements, in its resolutions, also say that a situation is occupied. However, this is the Security Council. It's an eminently political body. So if one of the 5 permanent members doesn't want to call a situation occupied or annexed, you're not going to have a resolution stating this. So at best, you might know whether or not the Security Council considers it as occupied, as annexed, but the fact it doesn't state it isn't indicative of anything. It could just be indicative that a permanent member doesn't want this. I don't think it's a surprise that we don't have anything from the Security Council on Ukraine, for example. States can also qualify a situation for a variety of reasons. And I think that increasingly we are seeing public statements by states qualifying situations. So I think we've seen a lot of states indicate that they consider that there is occupation in parts of Ukraine, in Crimea, and condemning the purported annexation. A number of states have indicated that they consider Gaza occupied as well. So we're seeing increasingly number of public statements by states, and also states have to qualify situations for their own purposes as well. Courts do so, often ex post facto, for example, in war crimes trials, but we're also seeing it as part of proceedings while conflicts are taking place. For example, the ICJ and the ICC at present. And then other actors do so. For example, the International Committee of the Red Cross has a qualification of every situation of violence in the world. It's not public, it's not binding on anyone, as aren't the others. But when you read the ICRC statements, you get a pretty clear idea of whether it considers a situation armed conflict or not. It's calling for compliance with IHL, whether it considers it occupation, if it calls upon the occupying power to do so. And obviously also PEGI's special procedures make their own determination. So a variety of actors for a variety of different reasons. None of these qualifications is actually binding in any shape or form. I think that's the problem. And also what all of us will have met is that not the same actors, all these actors don't necessarily have the same view. So we can look at them all to get an idea of the lay of the land, but nothing is actually binding.
Thank you. Thanks a million, Manuela. Super clear. Perhaps here turning back to you, Peggy, and here we'd like to learn a bit more about the linkages between the normative framework and the protection responsibilities of humanitarian actors. So particularly also including the agenda for protection and the IASC protection policy. So if you can shed some light on these points, Peggy, would be greatly appreciated.
Great, thanks, Mervat. When we think about the way that the responsibility for protection comes into it, you know, the key starting point, of course, is that responsibility lies with all of us, humanitarians and member states. And this is already the case from the 2016 UN protection policy. What has happened now, of course, is that we do have the Secretary General's Agenda for Protection, which reaffirms the importance of the UN's protection responsibilities, including in providing an effective and coherent response and making the UN accountable to the people that we serve. That response, of course, as we've said throughout this discussion, has to be anchored in humanitarian law, human rights law, and refugee law. And, you know, as stated, we as the UN and with our partners are facing increasing challenges in this. We see that the resources fall far short of our needs, and that has consequences for the speed and the reach and delivery of what we do. And we need to, as I think Jan emphasized, he spoke about risk sharing, but it's also burden sharing in this regard as well. You know, leveraging the operational space and our impact by working together as much as possible. Protection, of course, cannot be ignored. It's part, as I said, of our responsibilities. And that applies even when there are concerns around access and maintaining relations with duty bearers. We know it's not hard, but we really need to figure out ways to fulfill that full range of responsibilities, you know, continuing to have access, but also engaging on the protection side. For that to happen, the Secretary General has emphasized the need for greater collaboration among all the actors involved, sharing information and analysis of protection needs, building stronger advocacy, both public and private, to call on states and others to respect their obligations under both humanitarian law and human rights law. In that regard, of course, we look to humanitarian actors like those on the call, including civil society groups, to really exercise their own responsibilities and their role in helping us to collect and document and share information on international law violations, in order to help us preserve the normative frameworks and to ensure protection for all and greater accountability. And at the same time, of course, emphasizing the responsibility of member states and international organizations to support civil society actors in their operations in humanitarian emergencies, including through provision of adequate funding as a starting point, but also helping to respond, their ability to respond to these grave situations of human rights and humanitarian emergencies. So looking for a much broader and comprehensive approach that is supported and mutually reinforcing by member states, humanitarian actors, and of course the UN.
Thank you, Peggy. Super clear and informative. I want us to perhaps do a bit of reality check, and I want to turn to Jan here again, because I know, Jan, you've been quite active, of course, going on visits, meeting with communities, meeting with humanitarian workers. And from your recent visits, it would be great to shed some light on the realities on the ground in terms of practically what is required, what is it that's required for humanitarians to be able to deliver and access communities in needs, of course, specifically in occupied areas. And specifically, it would be great to shed light on the role of local actors and local organizations, because I'm sure, of course, during your visits, you've had the chance to meet with various local actors. It would be great to just shed some light on their role there. Over to you, please, Jan.
I mean, the realities vary a lot from whether it's an active conflict zone or it's just a very long occupation without very active hostilities. I mean, the West Bank, there has been low intensity conflict for continuously. But there is a big difference still between the West Bank and Gaza, which has been under the most intense bombardment of any urban area in recent memory, and with no escape, and with the borders closed. And of course, again, what's happening in eastern Ukraine now is an enormose war, basically, and intense shelling and crossfire. So I would say that much of this is actually also the ability to stay and deliver and to do risk management under hostilities and under in crossfire. It really pains me that we're not in the Russian occupied territories in Ukraine. I mean, there is a bit of there is some ICRC work and some a couple of NGOs and some limited, very limited UN work there. Very little, actually, and that again shows that the occupying power may actually keep out international actors that they may not see as completely neutral, unfortunately. In Gaza, it's an outrage at the moment. We're not getting in anything. Nothing is really coming in to a population under attack, and it's actually a fairly limited humanitarian presence there. I think there are we have some international staff. There are some from the UN, as you know very well, Merwa, International Red Cross, international and other international NGOs, health organizations. Maybe 175 to 180 international aid workers, and then it's the heroic national aid workers, of whom 200 have been killed, more or less. It's really a very horrific situation, which is not that different from warfare in other and more neglected circumstances. So perhaps the final point on the realities. At least there is attention on what's happening in Gaza and West Bank and eastern and southern Ukraine. There's not much attention on an equally bad war which is happening in Sudan, which today is the biggest humanitarian crisis on earth. Or for that matter, on the Congo, which is the biggest hunger crisis on earth, again in an active conflict setting, or across the Sahel, where there are now military regimes, and the humanitarian organization are basically pretty much alone as being in many places the international presence beyond the parties to the conflict.
Thank you, Jan, and thanks for shedding light on other contexts in the world, including Sudan and the DRC, and amongst many others that require also the attention and action from the international community. I want to turn here perhaps, and this is going to be perhaps the final round of questions before we turn to our speakers with their closing remarks and final reflections. So first to Emanuela, and here we'd like to know if you can advise on how do we put the balance between emphasizing the obligation of occupying powers and the pressure to not acknowledge the occupation. What steps could be taken concretely on this particular point? Over to you, Emanuela.
Thank you. I think that there's two different issues. One is situations where an occupying power denies that it is in occupation. And there, I think the reality is that different actors are going to have different objectives. So there's going to be humanitarian actors whose priority is to deliver. So rather than going toe-to-toe on whether or not the situation is occupied, it might be more conducive to allow them to operate, to kind of set that aside and manage to establish arrangements whereby they can operate, saying, let's not have a conversation, occupation, not occupation, but there are people in need. We want to be able to deliver according to these modalities. So taking a pragmatic approach to things, while there's going to be other actors, including within this room, who have a different objective, which might be to responsibilize the occupying power more generally. They don't have operations, they don't want to go and deliver, and they might continue this conversation of these are the reasons why we think this is an occupation and these are the rules that apply. And I think both approaches are important and necessary. But as Jan was hinting, the realities might be that if an operational agency is too pushy with regard to insisting on, for example, a qualification, it's simply going to be perceived as not neutral, and the occupying power might just say, nope, you can't come and operate here. I think it becomes technically more challenging in situations of purported annexation, and it's really going to get quite technical because humanitarian actors that want to respond might be forced to, might be pushed into situations where they might be required to do things such as register or pay taxes in a way that would amount to an implicit recognition of the title of the annexing state, purporting annexing state to the territory. So that's far more difficult. And again, it's a matter of striking the right balance. This is something that a lot of the actors responding in Luhansk and Donetsk post-2014 had to negotiate. Yes, the authorities there were entitled to play a role in determining who was going to be there, but it had to be done in a way that didn't amount to an implicit recognition.
Many thanks, Emanuela. So perhaps one more question, Peggy, directed to you. And here there's a question coming in around how do we reconcile between prolonged occupation and the temporary nature of occupation? What do we do in these circumstances?
Great, thank you, Mervat. I mean, the critical thing to think about, and it's a very important question and one that obviously in today's world has great relevance. The reality is the answer also reflects to what extent an occupying power is living up to its obligations under humanitarian law and human rights law. In a situation, if we could see one of those in the world where the occupying power was actually doing the things that we've talked about throughout this call is their responsibility, this would end up being more of a political question than a question of violation of human rights. The reality, of course, though, is that we see this distinction is all the more stark between temporary and prolonged occupation, and because those obligations are not being met. I guess I'd fall back on it and emphasize again the importance of thinking about how human rights law can be useful here, given that even when states refuse the qualification of occupation, and even when it's gone on for a substantial period of time, the states have there's an extraterritorial application of human rights obligations, and the human rights mechanisms have themselves been very clear in their general comments that those applications apply when states' behavior has human rights impacts outside their national territory. So that still applies in a situation of occupation, even if it's prolonged and illegal in a variety, in the way that we're talking about here.
Thanks a million, Peggy, and really a big thanks to all of our speakers. I actually want to take advantage of this time to perhaps turn first to Jan with your final reflection, final thoughts as we conclude this briefing. And of course, afterwards, we're going to turn to Peggy and Emanuela. So over to you, please, Jan, as we conclude.
Not that much to add, really. Although, number one, I think some of the occupations that we now see are unfortunately likely to be prolonged. Of course, the West occupation of the West Bank and Gaza has been there since 1967. It's the third generation now, people living under occupation. And there has been an occupation of Luhansk and Donetsk now since 2014. It's going to be longer term, so we have to adapt our ways of working to a long haul, and our objective is to help the civilian population, really. But we're not there to administer the crisis only. We're there to help them get out of the situation. And then again, I will repeat, which is a truism, there is no humanitarian solutions to humanitarian problems. It's political solutions. So, I mean, today, country Norway, Ireland and Spain recognize Palestine as a big move from Norway. I was myself involved in the Oslo Agreement negotiations and so on. And the argument is, this could and should bring a dynamic to the political process. There has to be a political end to the occupation There has to be negotiations also at the end for Ukraine. That's the only way of ending occupation, which should not be prolonged, and this for the benefit of the civilian population. And we are there in the meantime to help. And then we have to live by our humanitarian principles, which is in many ways a toolbox also for us, a way of acting in these situations as humanity, neutrality, impartiality, and independence. That's Bible, really. Thank you.
Thank you, Jan. Hugely appreciated. Again, as you pointed out, no humanitarian solutions to political problems and challenges. Over to you, please, Peggy, with your final remarks.
Thanks very much. I want to emphasize the point that Emanuela made and has come through Jan's remarks as well. We really do need to look at it as this broad toolbox of ways to try to engage with a constant focus on what can deliver for the people on the ground who are the ones affected by situations of occupation. And so that's why you've heard me emphasize the way, when one thing doesn't work, you might try to use human rights law. When compliance isn't happening, what are the tools there? And recognizing, as Emanuela said, that that different actors can emphasize things in different ways for greater effect. But alongside that is also that idea that our combined voices coming together and working together on these things and more clear, risk sharing, as Jan mentioned, and burden sharing is part of how we can, deliver the most in these circumstances. And I think there is always more that we can do to push that forward and, really take the points that have been made about the UN's role in doing more to secure access and to support humanitarian actors, and really open to looking at how my office uses our voice and ability to engage in that regard. And then the second and final point I'd make is really about the role of third states and that this is not just a situation that involves the parties to a conflict, and that states do have obligations under the Geneva Conventions. Jan just pointed out a way that some states are trying to exercise influence and leverage. That does apply more generally across all of these issues, and for all of us to really look for ways to encourage those states with influence to use it more to ensure compliance with the responsibilities of occupying powers. I mean, that's essential. Thanks.
Thank you, Peggy, and thanks again for highlighting the point that Emanuela mentioned earlier, which is the obligations in terms of IHL is not only limited to the occupying powers, but it is an obligation for all states. So the role of third states is absolutely, critical in this regard. Over to you, please, Emanuela.
Thank you. And just a couple of concluding reflection, again, picking up on the point that there's a range of different actors with a range of different roles to play, just to add another dimension in this. And we are talking humanitarian access here. And negotiations for humanitarian access are delicate humanitarian negotiations. So what I frequently say is, I actually think it might be counterproductive to have too much limelight on this. It is not helpful. I mean, there's certain rules of IHL where it is important to have everyone talking about them. With regard to access, maybe a little less political focus might, in fact, be more conducive to managing to get the access that is needed. So that's what I always say, including what can the Security Council do on humanitarian access? And I usually say, keep right out of it, might actually be the most helpful thing possible. And then some questions had come in about prolonged occupations and how do we deal with that? What are the obligations, for example, of occupying powers? And just to react to that is that as IHL looks at occupation, it doesn't foresee it as being a long-term situation. It's a temporary situation. So if you actually look at the nature of the obligations, they are pretty limited to life-saving support, maintaining public law and order, education, but it really does seem to be limited to a humanitarian situation. While we're looking at these prolonged occupation, we are looking at recovery, reconstruction, development, and the reality is that all of this, while necessary, fits very uncomfortably within the letter of IHL at least, and we need to look at other bodies of law, or the reality is that the law doesn't actually say so much. And then it's a question of engaging with all relevant stakeholders. And in regard to this, I would also say donors, because we see that donors in many contexts are willing to engage and support humanitarian activities, but far less so as we move towards reconstruction and development. And this is just a reality beyond situations of occupation.
Thank you, Manuela, and again, a big thanks to all of our speakers and panelists today. I think the objective of today has been achieved to a large extent, and a large part of it is really to raise awareness and better understanding, especially in the humanitarian, of course, sector, with regards to these important legal framework. Because Sian, as he pointed out, it is important to know the law, and it's important to recognize the obligations of both occupying powers, but also of other states, other member states, to be able to effectively deliver the required protection and assistance. I think it's important, of course, in the end, to be reminded that at the heart of all of these discussions are the lives of people, of real people. And you pointed them out, of course, the implications on communities, vulnerable communities, individuals and communities whose daily realities are shaped by the conditions that we've discussed today. So I take this opportunity to really express my sincere condolences to the innocent lives that have been lost, the suffering that has been caused due to the violations, and for not, of course, violations in terms of the application of IHL, and of course to the lives of our colleagues, whether it's national organizations or international organizations, and their families who have also suffered as a result of these violations. Again, a big thanks, Jan, a big thanks, Peggy, huge thanks also Emanuela, and for all of the colleagues that were able to join us today. And we look forward to engaging you in future discussions. Many, many thanks, colleagues.
Thank you, Mervat, Emanuela,
Thanks very
Peggy.
much.
Take care.
Take care. Bye-bye.